Hello, this is attorney Noreen Barcena of Barcena Law Offices in Pasadena, California. You can always reach me at 626-898-7200. Today I'm going to talk about something that I'm asked quite often from U.S. citizens that are over the age of 21, and they always ask if they can petition their undocumented parents. Sometimes I also get the undocumented parent calling me asking me, can my child who's 21 or over petition me or help me fix my papers? The answer is a little more complicated. So, in theory, a person should be able to get their residency through a U.S. citizen child that's over the age of 21. The reason for this is the laws in the United States say that if a person is 21 years old or older and they are a U.S. citizen, they can do a petition for their parent. And what that means is that they can ask for their parent to become a resident. Now, I like to think of this as a two-step process. And the reason for that is because the first step is doing the petition, the I-130 application. And then the second step is becoming a resident, which is the I-485. There's other ways to do it, like consular process, but for today's purposes, I'm only going to discuss adjustment of status here in the United States, which is the two forms that I've indicated. Now, the first step in every adjustment of status, specifically for parents and children 21 or over, is you have to do a family petition, and that's the U.S. citizen child saying to USCIS, which is the United States Citizenship and Immigration Services, hi, I am a U.S. citizen, I'm 21 or over, and I would like for my parent to be able to apply for residency. That's step one. Really, the I-130 form is just kind of indicating to USCIS that yes, this is a qualifying relationship. And the qualifying relationship is that I'm a US citizen, I'm over the age of 21, and I am able to apply for my parent and they can become an immediate relative of me. The second step is where a lot of problems kind of happen because in order to adjust status here in the United States, you have to have entered legally in the United States, and the person that has to have entered legally in the United States is the U.S. citizen's parent. So the parent has to have entered either with a visa, entered legally some other way. They have to have had some sort of admission, so that could be like TPS, temporary protective status for certain countries such as Haiti, El Salvador, Guatemala, and some other countries. Another way is if the person has what's called the 245I grandfather clause. Now that's an old statute where it was kind of decided that any application from April 31st, 2001, and before that, if a person applied for a work certification or a sibling applied for them, then that kind of locks in their petition. So the key is for people who are going to adjust status through the 245I grandfather clause, the people have to be able to prove that their application was approvable when filed. And that kind of means that, so for labor certifications, it was a legitimate business that submitted an application for the U.S. citizen's parent or the undocumented parent. And there's other ways as well to prove that. So if you do have questions, it is complicated, you're welcome to call our office or another attorney, 626-898-7200. But other than that, those are really the ways to apply for residency, which is step two. Now, so when someone asks, can I apply for my U.S. citizen parent, or can my U.S. citizen, can I, a U.S. citizen, apply for my undocumented parent, or can my U.S. citizen child apply for me? Sometimes the answer is no. but sometimes the answer is yes. Can you do a petition? You can always do a petition, and remember that's step one. You can prove that there's a relationship. But step two, the actual adjustment of status or the becoming of a resident, is where things get complicated because of the underlying rules that a person has to be admissible. This means that sometimes crimes can affect whether a person can become a resident. So let's say that someone did enter with a visa and does have a U.S. citizen child that's over the age of 21, but has committed 2 crimes of moral turpitude. And a common crime of moral turpitude is petty theft, so shoplifting. That person might not be eligible to apply. So the laws are a little complicated when it comes to immigration, but we're always happy to help here at Barcena Law. You can reach us at 626-898-7200. Thanks so much. And hopefully you have a great day and are staying safe during this COVID-19 period.